All right, we got a case here, Mathis versus Nationstar, and this case pretty much highlights all the mistakes that the average defense attorney or pro se litigant makes. Even though they had a favorable outcome with this appeals court, I don't know what the end result was, but I tell you, there's a whole lot of things that could have been avoided had they went in and done the simple PI work that requires hardly no effort, actually. But at least it would have positioned them a little different. And here what you have is they agreed to some kind of loan modification, and Nationstar rescinded on it. And I'm going to go ahead and give you a little bit of the background. I'm just going to touch on these points and why certain things happened to these people. Okay, so anyway, the plaintiffs executed a mortgage covering their primary residence. The defendant, Fannie Mae, later acquired ownership of the loan. Servicing of the loan was at some point transferred to the defendant, Nationstar Mortgage. Okay, two issues here. The defendant, Fannie, received or was given the ownership of the note. The defendants or the plaintiffs should have been notified. So that's number one. There should have been some kind of notification that transfer sale of the note as it pertains to the mortgage, section 20 or 22 or 15. It depends on what mortgage you have. But regardless, there's a notice of sale, a notice of transferring rights clause in all mortgages. Okay, so the second thing here is servicing of the loan was at some point transferred. Well, where is the hi and the hi we've taken over and the goodbye letter? And a lot of times an assignment. Nationstar should have had a welcome letter, and whoever their prior servicer was should have had a goodbye letter. And if that didn't happen, that's a conditions precedent that we're always talking about. And you're going to see it's riddled. This case is riddled with mistakes that we talk about in all our webinars and our calls. So anyway, Nationstar instructed the plaintiff. You see here, they instructed the plaintiff to stop making mortgage payments while it evaluated the loan modification request. The plaintiff obviously did so. And Nationstar later told the plaintiffs that they had been approved for some kind of trial period. Well, why would Nationstar tell me to stop making payments? Just think about this. That's ridiculous. And I guess it's an epidemic. It's happened all over the country with all these different servicers. But first and foremost, Nationstar is known as a default servicer. I personally sued them and won 3 times. And no problem at all. They are definitely a debt collector under most circumstances. And what I see here is they would be a debt collector if treated as such. Obviously, using unfair and unconscionable means, telling you to go ahead and stop. Again, the FTCPA is applicable here. How do you stop payment? It doesn't make any sense. But anyway, so these people, obviously, thinking that they were getting some kind of good deal or good advice, went ahead and were approved. They did what they were told, and they were approved. Now, goes on, the plaintiff successfully completed the trial period, and Nationstar sent a permanent modification agreement, which the plaintiff signed and returned to Nationstar. The plaintiffs then continued making the lowered monthly payments in accordance with the modification, and eventually Nationstar advised the plaintiffs that they had not accepted the offer or had withdrawn their request. They don't give a direct answer here, though neither was true, allegedly. Okay? They were told of the $11,000 in arrears, but the figures provided by Nationstar didn't give the plaintiff credit for the lowered payments that they had been making for several months. That's going to be critical because of several acts that have been passed and that affect a lot of the states. And that's going to be the grand finale here, and I'll show you how this works. And it does work, and it can work in any state. If anybody's done a mortgage modification and have been let down by the servicer, there's ways to get back at those guys. Anyway, they didn't give any credits. The $11,000 in arrears, the plaintiff's credit lowered payments they'd been making for several months. Nationstar refused. Okay, they refused to refund these monies or apply them to the claim deficiency. So somehow or other, Nationstar felt free to just hold on to people's money. And apparently, again, this happens quite often. Nationstar failed to pay the homeowner's insurance premium out of the escrow funds it held, resulting in cancellation of the policy. Okay? Nationstar then received an assignment of the deed of trust, which transferred the mortgage to Nationstar. Nationstar did not acquire ownership of the debt, but Nationstar, through its counsel, falsely represented to the contrary. Nationstar published foreclosure notices containing various falsehoods, and then it went ahead and conducted a foreclosure sale at which Fannie Mae bought the property. Okay? Prior to the foreclosure, Nationstar did not provide those plaintiffs notices and right to cure granted them by the mortgage, and that the notices contained material misrepresentations. Isn't this just on point with everything that we're talking about? They did not acquire the ownership, but they lied, false and misleading. Remember the list that I keep telling everybody over and over again? I'll say it again. Frequently violated FDCPA guidelines. They misrepresented themselves as the owners. And we know they cannot be the owners. Why is that? The heck just happened? Because, again, if you guys were to read the Fannie Mae Servicers Guidelines, you would see that it says the mortgage loan originator, seller, or servicer, any service bureau, or any other party providing services in connection with servicing a mortgage loan for or delivering a mortgage loan to Fannie Mae will have no right to possession of these documents and records except under the conditions specified by Fannie Mae. Any of these documents and records in possession of the mortgage loan originator, seller, or servicer, any service bureau, or any other party providing service in connection with selling a mortgage loan to or servicing a mortgage loan for Fannie Mae are restrained in a custodial capacity only. Retained in a custodial capacity only. They are never the owners. They are there strictly as a custodial of records, a custodian of records. They do not own it, so they can exercise a privilege again that they do not have. Remember, we talked about this. Now that's huge if you find out that your loan is a Freddie or Fannie loan, and you've done so through the guidelines and the lookups as we suggest to do in the early preliminary lookups. Had they done this, they could have stopped Nationstar in the tracks. Had they sued Nationstar under the FDCPA as a debt collector for misrepresenting or using unconscionable means means to collect a debt, that would have stopped them dead in their tracks too. They would have got their monies back. Nationstar couldn't just hold on to the cash. And I'm surprised that the court didn't make them return that money. I don't see anything in here. This is lengthy. Again, this will be posted down below. The complaint that they're suing for is breach of mortgage agreement, breach of the trial period agreement, negligence, wantonness, and wrongful foreclosure, which, listen, I have to agree with the judge. None of those matter here. The defendant present the following arguments. That the plaintiff did not satisfy conditions precedent to the suit. Look at the pot calling the kettle black. You're telling me you didn't give me a chance to rectify, but yet Nationstar never gave them a chance to rectify. That there is no private cause of action for failure to modify a loan. That's a fact. I don't have to be easy on you, and I don't have to agree to modify anything. There is no enforceable contract to modify the plaintiff's loan. That's true. Absolutely. So, and I get into other issues here with 12C, but that's not the problem here. The problem is, again, remember, they were told not to pay the mortgage. They went in and did not pay the mortgage. They got an agreement. They held their bargain up. Nationstar backs up on them. Nationstar threatens to take their home. Nationstar posts foreclosure filings in the newspapers there, apparently. And then Nationstar went ahead and sold the home after representing to whoever they were to the courts that they owned the mortgage and the loan. All these are clear violations of FDCPA, TILA, and whatever state laws are here in Alabama, which I'm not so sure. Anyway, conditions preceding. Again, the mortgage provides in pertinent part the following. Neither the borrower nor the lender may commence, join, or be joined to any judicial action as either an individual litigant or the member of a class that arises from any other party's actions pursuant to the security instrument or that alleges that the other party has breached any provision of or any duty owned by reason of the security instrument until such a borrower or lender has notified the other party with such a notice given in compliance with the requirement of Section 15. of such alleged breach and afforded the other party hereto a reasonable period after giving of such a notice to take corrective action. So what all that says is, listen, before you sue me or before you do anything, you got to give me a chance to fix it. And so, yeah. But guess what? With FDCPA and TILA, there's no chance to fix it. When you violate, you can't go back and not violate or correct the violation. So there's no, that's not applicable to these conditions had they followed the proper channels. Section 15 provides that all notices given to the borrower or lender in connection should be in writing. What do we always say? Put it in writing. That's absolutely critical, guys. Okay? The plaintiffs argue that Section 20 does not require notice prior to filing a foreclosure, only prior to suit. That's baloney. The suit was filed, the defendants foreclosed. Under Alabama law, a foreclosure sale extinguishes the mortgage. And once that mortgage was extinguished, they concluded that the notice requirement was extinguished as well. Baloney. That doesn't work that way. The defendants asserted, mind you, the defendant is not Nationstar, so make sure you keep track of it. The defendant next asserts that the notice provision requires notice not simply prior, but prior to foreclosure. So, finally, the defendants argued that the plaintiff cannot sue for breach of mortgage and simultaneously claim that the notice provisions contained in the mortgage has been extinguished on the grounds that Alabama law prohibits a person from picking and choosing the provisions in the contract that he wants to apply. And it makes total sense. Anyway, long story short, there is no private cause of action within HAMP. We know this, or at least I know this, and you guys should too. But the parties agree that Miller precludes a federal cause of action under HAMP. The question is whether and to what extent the plaintiff's state law claims are also precluded, which are not. Again, federal claims and state claims are two complete different issues. And once you guys read this entire case, you'll understand the difference. I can sue you under the FCCPA and not sue under federal, or I can sue under the federal and not sue under the state, or I can sue under both. One is not precluding the other. If there's no private right of action under the federal, but there is under the state, then I can get you in the state. See, there's no way around it. That's just the way the law works. Okay. So again, it's concluded that the absence of a private right of action from a federal statute provides no reason to dismiss a claim under a state law, just because it refers to or incorporates some elements of the federal law. And of course, you know, Nationstar is trying to use every angle they can to get out of this. I know their attorney has paid me quite a bit of money. Nice guy, by the way. Smart as a whip. That contract to modify. Obviously, the amended complaint alleges that the plaintiffs accepted the offer of the permanent loan modification agreement by signing the agreement and sending it to Nationstar. They argued that the loan modification agreement requires the plaintiff to return to Nationstar by June 1st, and that they didn't get it till June 7th. You know, it's a typical nonsense, and really no judge is going to stand for that. That's ridiculous. Especially the way loan modification does go down. You send them 55 times your paperwork, and 54 times they lose it or say they never got it. So no judge is going to buy that. Anyway, plaintiffs do not challenge. The plaintiffs do challenge the authenticity of the exhibit. So again, and with good reason, the actual loan modification agreement was signed by the plaintiffs and returned to Nationstar. But Exhibit A, which is a copy that Nationstar provided, is not signed by the plaintiff. And because the plaintiffs challenged that authenticity of Exhibit A, the court cannot consider it without converting the motion to one for summary judgment. Basically, without Exhibit A, the defendant, which is Nationstar, their arguments all collapse. So if they don't have the original signed agreement that was sent in by the plaintiff, their argument completely collapses because they're saying, well, we didn't sign it. Here's the original one with their signature, right? But we never did sign it. They could actually prove it that way. So anyway, long and order, they dismissed their motion for summary or judgment on the pleadings against the plaintiff here. The homeowner won this battle. But again, this could have been very easily resolved had it been handled appropriately. And all these skeletons that they somehow got around would have never popped up out of that closet. They would have all been put away nice and neat in orderly fashion when you have the proper records and the proper documentation. But again, let me tell you something. Most of the states have passed the laws, and I'm going to pop up Florida's here and I'll show you, which is basically the violations involving homeowners during the course of residential foreclosure. Let me put this up where you can see it. And this is right our Florida statutes, and you guys need to find your own. It's basically the Foreclosure Rescue Fraud Prevention Act, New Jersey, California, Florida, and I know several others have adapted it to their state legislation and put it into their statutes for good reason. And we used this argument a while back and said, wait a minute, if you take if you're telling me that you're going to take money up front and then we're going to review this account, and after that we might or might not give you a loan mod, that's pretty much a rescue scam. You've taken money, but now you're not doing anything. What have you done for the money? And you've taken money up front without giving some kind of resolution. So anyway, that Foreclosure Rescue Fraud Prevention Act would have been another defense against these guys, or an offense, because you could have sued against them for saying, hey, listen, you took $11,000 of my money, you told me not to pay, and now you're foreclosing on me, and you never showed me assignments. You're in violation of the federal law on both sides, the FDCPA. Here in Florida, it would have been the FDCPA, FCCPA, 559-715, which is the assignment of the mortgages, and you would have been in violation of TILA. So I could have hammered these guys down to nothing, and no problem at all had I followed the system. If I don't follow the system and one of those key elements is missing, you still would have succeeded. Just one or two. But here they had none. None of these people applied. None of these, and apparently they had counsel. So it doesn't surprise me, but the attorney, their defense attorney, never applied any of the KISS system, which is keep it simple, stupid. This is what you got to do, A, B, C, and D, and they never did that. So I don't know what the outcome is, guys, and I really don't care. It's just used for a purpose to show the members that if you don't follow the system, you can wind up in a pickle like this. And if it wasn't for the fact that Nationstar cannot or did not produce the original unsigned agreement on their end, that homeowner would have been done and cooked for no good reason. So, all right, keep studying, guys. Keep up the good work.